And welcome back to Moneymakers. Well, to continue our theme of inventors and innovators, one of the most important things to consider is protecting your idea in order to gain the maximum benefit for all your hard work.
Ian Hazan is from law firm Hazan Hoyer, and he's here to talk to us about how your intellectual property can be protected. Eve, welcome to the program.
Thank you, Matthew.
So tell us, we've registered our business name or we've registered our company. Why isn't that enough protection?
Matthew, what a business name registration gives you is the right to trade under that name, and it's really just an identification of you as the person trading under the name, but it doesn't actually give you any proprietary rights in the name. So you might find that although you get a business name registration, that someone who's been trading with a similar name for a long time will ask you not to use it, and you may not actually be entitled to use it.
I'm sure they won't ask you too politely. I can hear a lawyer getting involved there in 2 seconds.
Yes, well, you'll usually get a very long letter from some law firm saying you're using this name or you've registered this name, and that's contrary to the law, so please stop.
Okay, what are the most important areas to protect with trademarks?
The most important trademarks to protect is your business name if it's protectable. So if you pick a name that's not descriptive of your business, for example, if you were a fruit shop in the Balmain area, calling yourself Balmain Fruit Shop would not be protectable, and anyone else who's selling fruit in that area should be entitled to use that. But if you have a distinctive name, you should protect that name. Any brand names for product names, for example, if you're a clothing manufacturer or you're a designer, the trademarks under which you sell your goods should be protected, as for your logos and any special graphics that you use.
Okay. What about trade secrets, though? We were just talking a minute ago with our previous guest. Obviously, she's come up with an amazing innovation there. How do you protect those trade secrets?
One of the fundamental things with trade secrets, Matthew, that people often don't think about is that they have a lot of things that they do in their business which really are particular to them, that they just completely overlook. So it might be things like the processes that they use, the way that they put a product together, their customer lists, their supply lists, where they buy things. It may be things, simple things like computer programs that they use in their business, and they often overlook that as part of their assets. And the best way to protect them is keep it a secret. So don't go sharing them with people. Don't leave your customer lists laying around in the office for any visitor to see. And protect it that way.
I'm still trying to find out that formula for Coca-Cola. I'm sure I'll work it out eventually.
Well, they've been very good at keeping it a secret for a very long time, and that's basically the way to do it. A court will help you protect a secret if you've kept it a secret, but if you've published it and made it known to everybody, then the court's not really interested in helping you either.
Okay, tonight obviously we are talking about innovations and inventions. How can patents assist protecting these?
Well, patents are a very good way, a very effective way to protect inventions, because they give someone the exclusive right to effectively monopolise or to commercialise their invention. But one has to understand what we mean by the word protection, and often that's misunderstood amongst small business. And what protection means is the patent gives you a right to commence a legal action to stop someone from infringing your invention, so someone to do something similar.
So it doesn't stop them infringing it. This is more just giving you a right to take action against them.
It gives you the right to take action, and people should always understand that that is what they're buying when they're getting a patent, and often there's a misunderstanding about that. And so what I say to people is, if the reason to obtain it is to protect it, then have a fighting fund available so that when someone infringes, you can actually take action against them.
That's often tough for a small business. All right. As a small business, though, one of the things that you mentioned before is that we could be infringing on someone else's. How can you find out whether you are? Without waiting for the letter.
Well, the best idea is not to wait for the letter, so the best idea is to do a bit of due diligence. The government department called IP Australia has some databases which anyone can search over the internet, but searching is a specialised skill. And the best thing to do is to actually go to a professional whose business it is to search, to actually conduct the search for you. There's nothing wrong with doing an initial one yourself, just to make sure that there's not something obvious that's there, and keeping in mind that 75% of people who come up with inventions often on a first search will find that it's been done before.
Oh, okay, that's a good thing to know. How does a small business go about registering a trademark?
There are two ways. One way is to try and do it yourself through the government website. That's not usually recommended, because a fundamental part of that protection is to properly specify the goods or services for which you want protection. So going to get some professional advice is usually a good starting point.
Is it expensive to register a trademark?
Not expensive at all. I mean, we're probably looking at a couple of $1,000s if you use professional help.
Okay. Are there other things and other ways that businesses can protect themselves? Because it seems like there's so many myriads of risks here as far as people taking your IP.
Well, people often concentrate on the IP and the things that are a little more complex to get their heads around, but they overlook the basic fundamentals of any business, and that is the contracts that they get into. So often people have a great idea, a number of them will get together, start a business, but no shareholders agreement in place, no partnership agreement in place. They'll import a product from overseas, but they've never negotiated a distribution agreement. And these people often are a lawyer's dream, because the little bit of money they save in not having the agreements up front turns into litigation. So what I say to people is, when you're getting into a business, the first thing you should do is make sure you have all the necessary agreements in place, and they are really the foundation blocks of the business.
If there's someone watching tonight and they're going, oops, I haven't got those things in place, but I'm already in a partnership, is it now too late to get those things set up?
It's not too late, and the best thing they can do tomorrow morning or tonight is visit an appropriate lawyer to actually get those agreements put into place.
Well, when things do go wrong, though, what are some of the steps that you take? You've got to have it. Hopefully, you can try and reconcile it with the other party. Do you then go and sit there? Is it the next step is straight away to go and seek a lawyer and try and get good legal advice? Is that the first thing you should do, or are you jumping the gun?
I think sometimes you can be jumping the gun by getting lawyers involved too early. I think the best way to deal with these things is to try and have the dispute resolved by discussion.
Yeah, and often talking directly with them.
And often it's just a lack of communication. But the problem that often arises, and we see it day in, day out, is that because there's no agreement in place, people will then have different recollections of what was their agreement to start with. So a written document that sets it out is usually the best starting point.
Okay, well, I hope you can help us tonight also with a viewer question we have.
Yes,
We've got one here from Neil in Melbourne, and he's written to us asking, I own a carpet store which has been established 12 years. We've recently had an aggressive competitor open up in the same suburb with a very similar business name and company colours. What can I do? Is there anything actually Neil can do, or is he in deep trouble?
Well, let's make some assumptions about Neil. Let's assume that he doesn't have a trademark registration, because if he did, he'd know that he can stop the person because his trademark will give him the right to take action against them. And let's assume that he hasn't used a descriptive name. So, for example, carpet shop in Toorak, or Toorak Carpets.
Toorak Carpets, yes.
And he's got 12 years of use. If he's built up a reputation, especially in his area, he will be able to exercise what are known as common law rights. So he will be able to commence an action for passing off or for misleading and deceptive conduct. So the first thing to do is to get a letter out, preferably from his lawyers, telling the aggressive competitor to stop using the name. And if that competitor continues and refuses to stop, then he will have the right to go to the federal court and to commence an action for an injunction to force that competitor from using that name. The important thing is not to wait too long,
right,
because the longer he waits, the more he allows confusion to occur, and the more he allows the competitor to develop a reputation of his own.
Well, does that also make giving somewhat legitimacy to their position, that they're allowed to use that name? You've let them do it.
You've let them do it. You let them do it for a long time, and then you try and ask a judge to intervene quickly. So courts will usually help people who effectively help themselves.
Aside from just showing that you've been in business for, say, 12 years, how would you demonstrate that you've used the name? Is this a case of getting copies of advertisements and that sort of thing?
It's done in a variety of ways. The advertising you've done is your first point of call, and that doesn't need to be television advertising. It can be local newspapers, it can be brochures, it can be point of sale advertising, it can be shop front.
Okay. All right. Eke, thank you very much for joining us today.
Thank you, Matthew. It's a pleasure.